Let's get a word with Chris Daw KC, barrister, author of Justice on Trial. Afternoon to you, Chris. You as a defence lawyer have been involved in some very high-profile cases involving horrific and disturbing details, and I know as a lawyer, you know, it is your job to test the case of the state in situations such as this, even when they are of unspeakable horror like this. But in terms of the detail, Chris, we are now getting, as a seasoned and experienced lawyer, I mean, I'm pretty sure even by those impressive standards and your huge experience, these are shocking.
Well, they are, and I think in many ways the focus really should be on those who died and their families more than anything, because they're the ones who have paid the price for all of this. It is extraordinarily rare for children to be murdered at all. It is extraordinarily rare for children this young to be murdered, and of course it's almost unheard of, save in a tiny number of cases, for this number of children to be murdered in one event. So it is by any standards an extraordinary event, heartbreaking and desperate to see those faces on the screen of those three young girls.
We know, and as I just mentioned, this man, the accused, or the killer, as we can now refer to him, has been removed from court for a second time, and it sounds as if this person will probably not be there for the sentencing by the looks of things. I know we've talked about this before. I've always felt rather strongly that somebody should appear in court to literally, quite literally, physically face justice. You have a slightly different view on that.
Well, I'm not sure that it's in the interests of the family or of the sentencing process to have someone in court who is actively disturbing the proceedings, shouting, making noise, and generally kind of disrupting what should be a solemn and serious occasion, because whatever you make of him or any of those things, at the end of the day, this isn't about him. It's about the children who died, and it's about their families, and it's about, you know, the public seeing the process play out in a way that's appropriate for a legal proceeding. This is an 18-year-old who was 17 at the time, who clearly has, you know, very, very significant psychological issues as a very minimum, and probably something considerably more than that. And so I'm not sure that it helps anyone to have someone like that in a courtroom, kicking, screaming, shouting. It's one of those things. I understand people come down on both sides, but for me, I think the process should take priority over a desire to have somebody sitting there, whether they want to be there or not.
When families have to sit through this kind of evidence, and I would assume the families involved of the three young girls that were killed would already have been aware of some of that detail. It might not have been the first time, but often a courtroom is the first time some people have heard the more disturbing details of a case.
It is. It shouldn't be in the case of families of the deceased, those who are directly involved as victims, all the families of those who died. They should be fully informed in advance. They should be warned in advance of the nature of the evidence, and they should be given the opportunity to decide whether they want to sit and listen to it or not. And I'm sure that will have happened in a case like this.
Yeah, but nonetheless, I would imagine nothing, you know, you're used to being in a courtroom on the occasions that I've been in one, which is much safer. That parking ticket moment is mostly because a journalist. You know, they are places that can, you know, overwhelm people in many respects, and it's all, you know, even when you've been in possession of certain facts within the setting of a courtroom where, you know, some impressive men and women in wigs and people like yourself and a judge there, and the sort of the nature, the backdrop, certainly those old Victorian courtrooms of which we still have many. When that evidence is repeated in that setting, that's a fairly harrowing experience for many people, even if you're not directly affected. Certainly I've sat there and listened to some horrific detail of cases, and it's felt different in a courtroom than the pre-reports I might have read.
Yes, I think that's true. I think courtrooms are designed to be solemn places. They are places, of course, of, generally speaking, where there is quiet and order, generally speaking, where everybody is wearing very old-fashioned, traditional clothing. Not everybody, but certainly the barristers and the judge. and there is a certain sense that this is a place where very serious things are discussed and where very serious things happen, and that's the whole point. I mean, it is a courtroom after all, and a courtroom is there to deliver justice on behalf of the public in a way that is transparent, but also respects the seriousness of the events which are being discussed.
Just talk us through, if you can, Chris, because there's obviously been a lot of questions around this man in this particular case, this Rudakubana man who, had previous, if that's the way to look at it, certainly he was flagged to the authorities on multiple occasions. We've just found out that the prosecution stating in court that he 6 years ago called Childline and said, "God, why do you ever want to kill a child?" So we've got that kind of detail as well, just to add into the mix. Lots of talk of, a cover-up by the government. We should have known more details. I'm kind of torn on that because I understand the reason why we don't. But the bit that I've never quite understood on this case, and I know Starmer tried to address it, redefining terrorism, etc. He's been charged with some terrorist offences. That's largely about having ricin in his house or his bedroom, and an Al-Qaeda manual, which may have been a website or a page on his computer. But the killings themselves were not terror-related. What do you make of that, firstly? Because many would say, well, hang on a second, if you join the dots here, he's got an Al-Qaeda manual, he's got ricin knocking around, and then he goes on a killing spree, which, the MO of sort of Al-Qaeda type, ISIS sort of killers, that sits within that kind of category. Why is this man not a terrorist killer?
Well, I think ultimately that's a judgment that has to be made by those involved directly in the case who have seen all of the evidence. Although, of course, we as members of the public, and for this purposes of this case, I'm a member of the public. I've not been involved in this case in any way. I'm an expert, of course, but I haven't seen all of the evidence. I'm not sure that it takes us much further one way or the other. It won't make any difference to the tragic deaths of these children or of those who were injured and could have equally have died, whether one defines this as terrorism or the actions of a deeply disturbed teenager. For me, I'm not sure it makes that much difference. I think it's different if you're talking about a mature adult who, I mean, you mentioned a few minutes ago, and you've mentioned again the incident that happened when he called Childline. And by my maths, he would have been 12 years old. 12 years old when he did that.
Yeah.
And so you're dealing with a child who's clearly gone through some extraordinarily perverted development of some kind at some stage, which has led to this behaviour. Defining it as terrorism, does it make any difference in the end? I'm not sure that it does. These young children died in tragic circumstances, and for me, it almost doesn't matter why. What matters is that they died, and what matters is that we try to learn lessons from that for the future, to pick up on these things if children are, when they're very young, making threats of the kind that you've described. Plainly, there has to be some mechanism to properly look into that, because it's such an unusual thing. I mean, how many 12-year-olds threaten to kill children? I mean, let alone actually do it. I mean, it's almost unheard of for that to be done by a 12-year-old and to be a serious threat. So I think when it happens, it's something that should definitely set off some serious alarm bells, and that someone should be looking very carefully at the child and their psychological development and their behaviour, because of the risk that it gets, the state that it did.
And that is a different offence, is it? So you could be charged with murder, but if the murder is against the backdrop of your affinity to a terrorist group, that is a different offence, in the same way that you can assault somebody, but racially aggravated assault will carry a bit of sentence.
No, it's not. It's not a different offence. It's still murder, whether it's a terrorist motive or a paedophile motive or any other motive. It's still just murder, and that's intentional, taking a life intentionally. The difference is that because terrorism is considered to be something that might be deterred, there are increased sentences where terrorism is a motivational factor in a crime or a murder, because judges want to be heard, and and politicians want judges to be heard saying, you know, this was terrorism and therefore the sentence is increased because we want to send a message out to anyone else who is thinking about terrorism. Now, whether or not that actually has any impact on potential terrorists is a different issue, but that's plainly the mindset of the system is, if it's terrorism, we need to send out a message to try, if we can, to deter others.
The sentencing, of course, will be taking into account the age this man was when he carried out these offences. He was 17, so therefore things like a whole life sentence will not apply. That's the law of the land. Does that need changing, Chris?
No, I don't think it does need changing. I'm not a fan of whole life sentences, full stop, because I think the system should have built into it the possibility that at some stage, even if it's only hypothetical, at some stage there will be some sort of redemption and risk reduction. In a case like this, and not knowing the detail, not having read psychological or other reports, it seems highly improbable that he will ever be released. But if he is, I suspect he will be an old man, and you know, and only at a point when the parole board, in many decades' time, come to the conclusion that it would be safe to release him. That time, of course, may never come.
He's charged with multiple offences, of course, murder, attempted murder, and then, of course, there's the terrorist-related stuff, the manual and the writing, etc. We often hear judges say, you know, you're sentenced to this amount of years for that offence, that amount of years, and they will run concurrently. We don't often hear a judge say they will run consecutively.
Well, we do, but not for life sentences, because obviously by definition you can't have consecutive life sentences, because we only get one lifetime. So life sentences always run concurrently, and the only issue that matters for a life sentence is the minimum term that is set by the judge, which means the absolute minimum that the person will spend in prison, and that is the figure which we're going to hear from the judge at some point today.
A life sentence, as I understand it, is different than for somebody under 18. The minimums change, is that right?
Yes, that's right. Although he, of course, is now 18 and therefore is being sentenced as an adult. But yes, there are differences, and the levels of sentence for those who are 17 at the time of the offence are different, and indeed the sentencing is different for 18, 19 and 20-year-olds too.
So he'll be sentenced as an adult, even though he committed these offences as under 18?
Yes, absolutely. Yes, he will be sentenced as an adult, because you are sentenced at the time of the age at the time of sentence dictates the sentencing regime, although there is a specific legal provision which says that if you are 17 at the time of the crime, even if you're 18 when you're sentenced, you cannot receive a whole life order, which is what you referred to earlier.
But you could receive a minimum of 45 years.
Oh, 50 years, absolutely. Yeah.
Well, what is the longest you've ever seen somebody sentenced? I think we had, I think the Christmas Eve killing in Liverpool, I think was something like 49 years or something like that.
Yes. Well, obviously, we've all heard of these killers who received whole life orders. There are only about 70 or round about 70 prisoners in the country serving a whole life sentence. But for anyone who doesn't receive a whole life sentence, then for obvious reasons, it's rarely going to be more than 45 to 50 years, because that will generally, in most cases, take the person past the date at which they're likely to have died.
Yeah. And just a point on what happened after these attacks. There was a vigil the very next day, of course, in Southport. Meanwhile, in another postcode, there were riots. And Keir Starmer, of course, made his points known on that. People were given, in some cases, quite lengthy jail sentences. I know the word riot changes the sentence if that is specifically what you're charged with, as distinct from some other public order offence. You were not a big supporter of people being jailed for Facebook and Twitter posts.
No, not at all. Our prisons are absolutely chock full. Our courts are absolutely chock full, and I don't think that prison is the place for people who make offensive, angry, abusive comments on the internet. I just don't think we have the capacity in our system for those people to be locked up. And there is obviously an argument to be had about freedom of speech and freedom of comment, even if you want to be offensive. And for me, I think we've got to the point where we are too willing to have police involvement in things that happen on the internet, often on international websites where there's no prospect of tracking the people down or what have you. And I think the police's time is much better spent on our streets, policing the streets, rather than policing the internet.
Yeah. And just a final one on Keir Starmer, because he, of course, stood accused of not giving enough information about this. He said he would prejudice a trial. I understand he took advice on that. He was told, don't go there, this is too complex and there's lots of facets to it, and every time you'll mention one thing you'll land yourself in the thick of it, etc. So he chose to really say nothing at all. They absolutely refuted any terror connection with this guy, which in retrospect, perhaps they could have said something, but Mr. Starmer's view was it could prejudice a trial, which is true, but there are things you can say. The reason I raised that, Chris, when the riots took place, Mr. Starmer was very quick, along with Angela Rayner and others, to talk about far-right protesters. A lot of those people who ended up before a judge pleaded guilty. They were advised to plead guilty. They thought that was the best way. Had it gone to trial, to full trial, would a defence lawyer like yourself have argued my client can't have a fair trial because the Prime Minister has already prejudiced the trial by telling the world that my client is a far-right lunatic?
Well, I'm sure that some of the lawyers may have sought to argue that, but it wouldn't have just been the Prime Minister. And the Prime Minister, of course, is not just the Prime Minister. He was also the Director of Public Prosecution. So he would know better than anyone what you can and can't say to avoid prejudicing a trial. I mean, he may have taken advice, but frankly, he didn't need it. You'd be a bit worried if he didn't know the rules, wouldn't you, if he was running the whole prosecution system for a few years?
True.
No, I mean, I think the Prime Minister and any politician who dives into a case that's before the criminal court and starts making comments about it, particularly if it's done in a way deliberately to antagonise and to wind up the public and to make emotional remarks, it's just unwise and unhelpful for that to happen.
And that would include the far-right comments as well?
Of course, absolutely. I don't think politicians, and we've seen it rather too much in recent years, particularly from the last government, but also, frankly, from all governments, politicians are all too willing to go on TV or on the radio and give their personal opinion, often based on zero knowledge of the evidence about a particular case. And the legal system then has to pick up the pieces of those politicians doing that and find a way to ensure there's a fair trial. It would be much, much better if politicians stayed out of legal matters until they reach the conclusion. And once they've been concluded, anyone's entitled to have their say.
Chris, as ever, thank you. Always a thorough chat with Daw KC.